Well, welcome to the Moot Court. Let me tell you about the problem.
No, Richard,
Nope.
I'm going to introduce you. I got to do some announcements.
You got to do an announcement?
Yes, I
We'll do the announcements. Don't keep the judges waiting.
I was just checking. Okay, welcome everyone. My name is Jackie Steele, and I want to welcome you to the 2023 Earle Zehmer National Moot Court Competition Finals. We are so happy to have all of you here, but I wanted to give you some background information so that you understand what it took for these students to be here today. The competition is a national competition, and we had 45 judges participating from 9 states in the preliminary rounds before the students advanced to this round today. The judges came from Florida, Georgia, Tennessee, Louisiana, Missouri, Kansas, Virginia, Wisconsin, and Mississippi. There were 26 teams of law students from 10 different states, including Florida, Texas, Michigan, Mississippi, Arizona, Tennessee, Rhode Island, Kentucky, Louisiana, and Virginia. And these are the final 2 teams that advanced through those oral arguments in the preliminary virtual rounds, then the quarterfinal rounds, and the semifinal rounds that occurred yesterday. And so we are very happy to present this program to you. And I just wanted to give you a little bit of that information because they really have done an amazing job, and we're glad to have you all here to witness these arguments. Richard Sicking is going to give a presentation as to the problem so that you'll have a little bit of information about the arguments that you're about to hear before the marshal convenes the first DCA. Thank you so much.
Now for the problem then. Well, before World War II, the auto union in Germany was like our General Motors. They produced a number of different makes of automobiles, but their high-end luxury car was the Horsch, which they stopped making in 1939. After the war, they've used the name by their initials, Audi, as Auto Union Deutsche Industrie, Auto Union German Industry. And they are now owned by the Volkswagen Group, as you might well imagine. In 2021, they revived the Horsch automobile as a super luxury brand to compete with Mercedes-Benz Maybach. Now comes the catch. They only sell it in China. You can Google and then you can see a picture of this magnificent automobile, but it's not available in the United States. That part of the problem is fact. Now for the fiction. Audi decides they're going to try and sell the car in the United States, but they're concerned about servicing and maybe let's try it in a small, out-of-the-way market, just a few cars and see how it goes. And so they decide to connect with the Minnesgrüner brothers, who have the dealerships in Georgia and Florida, to send 2 cars, one to Tallahassee and one to Thomasville, which is north of Tallahassee, just over the state line. And of course, to facilitate the servicing, they engage Franz Gruber, who's a master mechanic at the factory, and they approach him about going to the United States, to Georgia and Florida, and he's thinking palm trees and beaches, and he's a single, and he thinks this would be a great adventure, so he says yes, and they put him on a plane from Dresden to Atlanta. One of the brothers meets him in Atlanta, takes him to the dealership there, and presents him with a written document he calls contract. Now, the work is for an indefinite period of time. The pay will be $1,500 a week. It will be 40 hours, but it will be 4 tens. 2 10-hour days in Tallahassee, Monday and Tuesday, and then 2 10-hour days in Thomasville, splitting Florida and Georgia. Also, he'll get a 10% commission on any accessories, modifications, extras that are sold. There are 2 clauses, though, in the contract, which you may recognize. One is a non-disclosure of business secrets clause, and the other is a non-competition clause from 1 year following termination. And one of the twins after they sign, drives him to now Havana, Florida, which is between Thomasville and Tallahassee, because the manager of the dealership in Tallahassee has a fully furnished carriage house, which is part of the contract they're going to provide to him, and of course a car, an Audi A4, of course, and health insurance. He settles into the carriage house, and the following Monday, he reports for work at the Florida dealership. In a few days, the two horses are delivered, the one to Georgia and the one to Florida. And the one to Florida is heralded with TV coverage and everything. So a lobbyist in Florida, in Tallahassee, he grabs it up. But he wants a lot of fancy modifications, and he enters into agreement with the dealer. It's going to cost an extra $26,000. And he's very pleased that they have a master mechanic from the factory to, do all that. And that's what Franz Gruber does. He makes the modifications. The car is delivered to the lobbyist, and then his life just goes on because they don't sell a car in Georgia. And all he's doing is going back and forth and just training the other mechanics about things and doing demonstrations and stuff. And then eventually, one day when he's in Georgia, he's given a check for the $2,600, which is his 10% commission on the modifications that he made for the lobbyist car, in addition to his salary. And then in May, he's working on the Georgia horse, and he's down in the pit, and he has the same accident that Jay Leno had, if you remember that from the news. The gas tank springs a leak and just sprays a little bit of gas vapor out on his face and his neck. And as he moves out of the way, the tool hits something on the car and makes the tiniest spark that ignites the gas, and he's burned all over his face and his neck. So he's taken to the local hospital, and then arrangements are sent to him to the University of Florida Medical School Hospital, Shands in Gainesville. And he's there, and at some point, one of the twins comes and brings him a check for some $700. That's the workers' compensation under Georgia law. He's not real happy about this, but that's what he, except there's another patient there who befriends him, who got hurt in Florida, and he tells him, "Hey, you were working in Florida. You should get the Florida rate like I'm getting, and that's $1,099. You got to call my lawyer." So he does, and they make the connection, and they do the necessary paperwork, and the lawyer files a claim for coverage of the accident that happened in Georgia under the Florida workers' compensation law, and it's assigned to the workers' compensation judge in Tallahassee. He hears the case, and he determines, one, that there is coverage in Florida, and also he finds that the average weekly wage includes the bonus that was paid to him when he was in Georgia. The insurance carrier has appealed to the Florida First District Court of Appeal. Everyone has filed their briefs, and you are now going to hear the oral argument in this case before the judges of the First District Court of Appeal, who will appear very shortly.
Shall be heard. May God save these United States, the great state of Florida, this honorable court. Please be seated. We have one case scheduled for oral argument this afternoon, the case of Gruberger Motorworks Audi America versus France Gruber. Counsel ready to proceed? You may approach counsel. We will allow 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 2 minutes for rebuttal.
So noted, Madam Clerk. You may proceed, counsel.
Thank you. May it please the court, my name is Emily Mann, alongside my co-counsel Nadine Cox, and we are pleased to represent the appellant, Munich Insurance Company, in the present appeal. There are 2 issues for the court's consideration on review. I will be addressing the first issue, and I will demonstrate that the appellee's workers' compensation claim is not compensable under Florida law. My co-counsel will address the second issue, and she will explain why the judge of compensation claims erred in calculating the average weekly wage. Your Honors, this court should reverse the decision of the JCC on the first issue for 2 specific reasons. First, Mr. Gruber's employment contract was made in Georgia, not Florida. And second, neither the time distribution within the claimant's workday nor the employment-related contacts are sufficient to establish principal localization of employment in Florida. Under Section 440.091D, a Florida employee that's injured outside the state of Florida can still seek compensation under Florida law, but the success of that claim is contingent on satisfying one of 2 paths to compensability. The first is that the contract be made in Florida, and the second is that the contract or the claimant's employment be principally localized in Florida.
Regarding the second element, counsel, wasn't claimant's employment principally localized in Florida, given that he resided there pursuant to the employment contract, in addition to working there 50% of the time, and thereby spent most of his time in Florida?
Respectfully, Your Honor, we would disagree that it was principally localized in Florida. To turn first to the time distribution that you discussed, Judge Lewis, the time distribution is 50-50 split. But as this court considers principal localization of employment in Johnson versus United Airlines, that 50-50 isn't enough. It has to be the focal point of the employment for there to be principal localization. And now turning to the second point you bring up, Judge Lewis, in regards to the residency contact, if this court moves from a time distribution analysis alone into an employment-related contact analysis, residency is not something that this court considers. In fact, residency would be personal time, not employment time. And in General Electric versus DeCubis, this court interprets the legislative language of Section 440.091D and narrows the scope from
So the amount of his work was split 50-50. Okay, I think that's reasonably clear. And he was working on Audis in both places. But it seems like the nexus to Florida is much greater because the real technical work, the thing he was brought over here to do, was to get these horses ready. And the only one that that got sold that had substantial modification to it was the Florida one.
When the court considers time distribution, looking at what he was hired to do isn't necessarily in the court's consideration. When the court considers time distribution, it's not the performance and what he's working on, but how he's allocating that time. Where is he allocating that time, and for what employer? Is he in Florida when he's doing that work? That's something that this court considers, but not particularly what the work he's doing. As indicated on page 2 of the record, Mr. Gruber worked a 2-day in Florida schedule and a 2-day in Georgia schedule. That's a 50-50 split. As to what work he was performing, all of that is compiled within the workday itself.
But wasn't the claimant required to report to work at the Florida dealership as a condition subsequent to the execution of the employment contract, making Florida the location where the contract was made?
So that would bring us back into this first path to compensability, the contract for employment. And we do acknowledge that he had to work in Florida, Your Honor, but his arrival in Florida wasn't conditioned on binding the employment agreement. So as this court interprets how a contract is made, Florida courts have long recognized that the last act necessary to make the agreement binding is what binds the employment agreement. Here, it wasn't his arrival in Florida because it wasn't conditional. It's not a condition in the contract. It was the signature on the contract.
So how would you distinguish Rahoff Agencies, Inc. versus Peterson?
That was dealing with a unilateral contract, Your Honor. Rahoff Peterson's decision was a Supreme Court decision where this court breaks down the difference between a unilateral contract and a bilateral contract. A unilateral contract the performance binds the contract. It's an if-then, it's conditional. If the claimant arrives in Florida, then it would bind the agreement. But we don't have those facts in our record.
But you're saying that the everything that was necessary for the contract, the meetings of the minds, happened in Georgia?
Yes, Your Honor.
Or Germany?
In Georgia.
Okay.
Is it a question of fact, or what's our standard review here?
It's a question of law in this instance, because what legal standard the court applies in interpreting where a contract is made, that's a legal determination that this court has to make. And under Fredericks versus United Airlines, when this court makes a legal determination, it's de novo.
Well, what about the other part of it, the principally localized in the state? Isn't that sounds like a question of fact, not a legal question?
Principal localization in this case, some of the facts found in the record are the facts found in the record. They're undisputed. But in regards to what contact should be considered, whether a residency contact is employment related or not employment related, that's a legal determination that this court has to make. What contacts should be included in the legal analysis, and because of that, it's a de novo standard of review.
And what did the JCC determine in this case on that question?
The JCC held in favor of the appellee on both instances, that the contract was made in Florida and that the employment was principally localized in Florida. But it's our position that the legal standard was misapplied. And because the legal standard was misapplied, we ask that this court review it on the standard of de novo.
But did the JCC make that determination based on evidence that was before them?
The JCC did rely on evidence that was in the record, Your Honor. However, while that evidence is in the record, and those are the facts that this court has as well, the court can give deference in regard to the factual inquiries and the factual findings, but in regards to a legal determination, that is de novo. So we acknowledge in regards to the factual determinations that this court will give deference, but this court doesn't have to in the legal determination.
Had the claimant not reported to the Florida dealership, would the non-competition and the business secrets non-disclosure clauses of the contract still apply?
Your Honor, I see that I'm running close to being out of time. May I briefly
You may respond.
Yes, Your Honor. So when he arrives in Florida, it's our position that arrival was not conditional on binding the contract. What bound this employment agreement was the signature, because it was a bilateral contract. The terms were presented to the claimant upon his arrival in the United States. The employer presents that contract. The claimant signs that contract in the state of Georgia. That's what bound the agreement, not his arrival in Florida. This is a bilateral contract, and it is for the foregoing reasons that we respectfully request that this court reverse the decision of the JCC and find the claim compensable.
Thank you, counsel. You may proceed, counsel.
May it please the court. My name is Nadine Cox, and I too represent the appellant, Munich Insurance Company, in the present appeal. Your Honors, I will be addressing the second issue, and I will demonstrate that the judge of compensation claims did err in finding Mr. Gruber's average weekly wage to be $1,700 based on the 13-week period prior to the accident. Your Honors, this court should reverse the decision of the JCC because Mr. Gruber did not earn the commission within the relevant 13-week time period. Now, turning to the reason
What
why—
would be the effect if we vacated the JCC's order and we just left it at that? What happens from there?
Your Honor, in that instance, the average weekly wage would be $1,700.
Based on what? If we just vacated it, how would that work? I mean, if it goes back to the JCC, assuming the process is what it is, how would it end up being $1,700 just by itself without us doing anything?
Well, Your Honor, that would mean that the commission is included, and that would mean that the commission was not. That would mean that it was an incorrect standard for what earned means under Section 440.141A. Additionally, if this court were to vacate, it would also mean that it would be applying a different legal standard that's not supported in the record. If this court were to apply a different legal standard or a different definition of earned, there would have to be facts in the record to support that idea. And Your Honors, the burden—
But assuming for the sake of argument that we agree with your argument that we should reverse the JCC on this point, why shouldn't we remand it to the JCC for an evidentiary hearing so the claimant could present evidence of the value of the housing and the vehicle he was provided to be included in the calculation of the average weekly wage.
Respectfully, Your Honor, appellant is not asking this court to remand with instructions to determine the value of the housing because, Your Honor, that issue was waived because it was never before the JCC. And as this court in Smith versus Sunland Tanning Center determined that because the issue of housing as well as health benefits was not before the JCC, the claimant in that case waived the opportunity to raise it on appeal. Additionally, the claimant in that case was entitled to benefits. However, because it was not raised, it was no longer an issue before the court.
Yeah, but it's not an issue before this court at the time. But if we vacate an order, that order is no longer in existence. And it goes back to whether we remand with instructions or just vacate. It just goes back to the JCC, and there's no order resolving the compensation claim. So the JCC is going to have to do something one way or the other. What's the JCC going to do? I mean, it has to do something.
Yes, Your Honor. So we would ask this court to reverse with instructions to direct judgment on the issue that the commission is earned when the work is completed, and not include additional look into facts for the health benefits or the housing. But turning to the issue of when a commission is earned, pursuant to Section 440.141A, it's the statute specifically requires that an average weekly wage be calculated based on 1/13 of the wages earned. And this court has found that significant. In Witzke versus West Coast Duplicating and Claim Center, this court made the distinction between earned wages and paid wages. And this is important when we look to the record because we see that the time period for the average weekly wage calculation begins on February 22nd. And we also see that it ends on May 21st. This is because the injury occurred on May 27th.
The claimant relies on this court's opinion in National Distillers versus Guthrie in support of the argument that a commission is earned on actual receipt of income. Can you distinguish Guthrie?
Yes, Your Honor. In this case, Your Honor, we're dealing with the fact that the work was completed on the February 15th date. Now, Your Honor, this court hasn't looked to the date of the payment of the employer because that's not the relevant consideration. The relevant consideration for an average weekly wage calculation is when the work is completed. The Fifth District Court in Comerford versus Sunshine Network determined that a commission is generally deemed earned when the work is completed, regardless of whether the principal is paid at a later time or the good is delivered at a later time. Additionally, Your Honors, this is a de novo standard of review because this is a question of law. It's a legal determination of what does earned mean. Additionally, Your Honors, this court can't look to just the payroll or the pay period or the paycheck in determining what is earned, because that would essentially be changing the language of the statute.
But wouldn't the exclusion of the commission from the payment of from the average weekly wage calculation unfairly ignore a claimant's income-producing services, as well as the contracting party's expectation that income from commission will be included in his wages?
No, Your Honor, it would not in this instance. And now we do recognize that this court has applied a more flexible interpretation. However, in all of the cases that this court has done so, it's been a weekly commission. Your Honors, there were 2 vehicles in the United States where Mr. Gruber could earn commission upon the vehicles. And Your Honors, it was a one-time commission payment, so it wouldn't unfairly represent his loss of future earnings because it was a one-time payment. It would be different if this was a weekly occurrence. But Your Honors, this court in Story Mountain versus George determined that a legislature says in the statute what it means and means in the statute what it says. And the statute says earned. This court doesn't look to any other date. It doesn't look to any other payment, and it doesn't look to the pay period because that would mean that wages earned equals wages paid. Thank you.
Thank you, counsel. You may proceed, counsel.
Good afternoon, Your Honors, and may it please the court. My name is Sean Brew, and I represent the claimant in this matter, Mr. Franz Gruber. I will address the first issue on appeal and argue that the JCC properly concluded that Florida law covers Mr. Gruber's claim. My co-counsel, Mr. Jake Pudula, will address the proper calculation of weekly wages. As a matter of policy, Florida aspires to provide anyone in whom it has a sufficient interest with Florida workers' compensation benefits when that person's injured on the job.
Where does that policy come from?
Your Honor, it comes from this court's case in Philyaw versus Arthur H. Inc. When
Do we make law in the state of Florida? Do we make policy for the state?
No, Your Honor, but the policy informs the coverage statutes as this court recognized in Philyaw versus Arthur H.
So where does the policy come from that you're referring to? If you're going to lead with public policy, I'd like to know where that public policy is coming from.
Your Honor, I would say that it's coming from the legislature expressed in its intent in providing broad coverage for injuries even outside of the state. But the statute is also supported here for two reasons. First, Mr. Gruber's temporal distribution of work supports that his employment was principally localized in Florida. And second, Mr. Gruber's employment-related contacts primarily lie in Florida, which further supports that his employment was principally localized.
But how come Mr. Gruber would be considered principally localized in Florida when he spent 2 days a week in Florida and 2 days a week in Georgia?
Your Honor, page 2 of the record does indicate that the contract contemplated a 50-50 split here, but there are later 2 quotes in the record on page 3 and 4 that when read together is a permissible reading that he actually spent a little more time in Florida throughout the totality of his employment. Now, Judge Tannenbaum, earlier you asked what the standard of review on the principal localization question is. It's competent substantial evidence review. This is a sufficiency of evidence case. In this court in Colson versus State Farm Bank said that sufficiency of evidence is reviewed under competent substantial evidence review. And specifically related to this statute, this court in Hazeela for you versus Labor Ready applied competent substantial evidence review to the principal localization question when it was a sufficiency of evidence test. Now this means—
So you don't think it's a jurisdictional question. You just think it's a matter that the JCC can determine whether it's compensable under Chapter 440 of the Florida statutes, which is a fact determination, at least with respect to the principal localization.
Your Honor, I do think it's a jurisdictional question, but I think it's whether the claimant provided sufficient evidence to establish jurisdiction in Florida.
Okay, but doesn't the JCC have jurisdiction over a PFB to determine whether there's compensability? And if it's not compensable because it happened in another state, that's a question of whether it's compensable, not whether the JCC had the authority to rule on the PFB. Or does it make a difference?
Your Honor, I apologize. I thought you were referring to the coverage statute generally as whether Florida can provide coverage as a jurisdictional matter. The JCC does have jurisdiction over this case.
Right.
But the standard of review here is competent substantial evidence review. That means that the appellant has to do more than recite contradictory evidence on the record. That also means that even if this court would have weighed the evidence in a little bit different matter, this court should not substitute its judgment for the JCC's judgment. It's a highly deferential—
Counsel, is it your position that Mr. Gruber was working temporarily in Georgia? If so, why?
Your Honor, I don't think he was working temporarily in Georgia because I think the record reflects, if you look from the date of his hire to May 27th when he was injured, that he would have spent more time, more than 25 days in Georgia, which under the extraterritorial reciprocity statute, Florida statute 440.094, section 2, that's the requirement. I think he would have been working longer than 25 days in Georgia over the duration of his employment. That's not our position here. Our position is that the temporal distribution of work favors Florida and that his employment contacts primarily lie in Florida. Now, to my point about the temporal distribution in the contract contemplating a 50-50 split, under the competent substantial evidence review, this court's case in Bonagura versus Home Depot says that whenever there's a permissible way to read the record and its evidence and its permissible inferences, this court should adopt that reading if it supports the JCC's decision. And those quotes on page 3 and 4 are a permissible reading of the record that supports the JCC's decision. Page 3 of the record shows that when the Tallahassee porch was agreed to be purchased on February 10th, which was a Thursday, Josef Furneskruner said that he had a master mechanic at the dealership to perform those modifications. That shows that on a Thursday, February 10th, instead of being in Georgia where he should have been under the contract, he was actually in Florida. If this court's hesitant to adopt that reading based on that quote alone, page 4 of the record further supports that position. Page 4 of the record says that after his initial period of employment with Twins Audi Motors, where he's spending time making modifications and other things in Florida. He then settled into his routine of 2 days a week in Florida and 2 days a week in Georgia, indicating he wasn't already following that routine. And the only evidence on the record that supports that he was spending more time in one state versus the other is the quote on page 3 that suggests he was spending more time in Florida at the beginning of his employment.
Now, the appellant argues that this is actually a de novo review because the JCC applied the wrong factors or applied the wrong, reading of the law. What's your response to that?
Your Honor, I don't think the JCC applied the wrong reading of the law. There's no dispute that this is a totality of the circumstances test, probing for where the focal point of his employment was. Applied that law. This is a sufficiency of evidence case, and the appellant 4 times throughout their argument said that there was insufficient evidence to support the JCC's decision.
Well, but what if the evidence was that Mr. Gruber vacationed on weekends in Florida, on the beaches of Florida, and the JCC relied on that and discounted the amount of time he spent working in Georgia? Is the JCC entitled to make that consideration? Is there nothing we can do to touch that determination?
I think in that case that would be de novo, and I think that would be a legally insufficient basis because we're looking at employment-related contacts. But the record's replete with employment-related contacts that support Florida, and that brings me to my second point.
But isn't the EC's position supported by the facts that the employment contract was signed in Georgia and that Mr. Gruber's injury occurred there also?
Your Honor, I concede that the contract was formed in Georgia. The last act necessary in a bilateral written contract under DL Peoples Group versus Hawley is the signature of the contract. But 440.09 section 1 subsection D is a disjunctive test. So regardless of where the contract was made, so long as someone's employment is principally localized in Florida, which it is here, Florida law covers it. So for the employment-related contacts, one employment-related contact you can find on page 2 of the record, which is a relevant consideration, is the employer provided housing. In 1974, the statute was amended to remove residence as a sole basis for coverage, but it doesn't mean that that's not a relevant consideration. And in the second paragraph of this court's General Electric versus DeCubis test, it noted where the claimant in that case resided and then later said that these facts undisputably resolved that his employment was principally localized in Florida. This was a Florida-provided house from a Florida-provided manager from a Florida company. That is Your Honor, I see that I'm out of time. May I briefly conclude?
You may conclude, counsel.
Your Honor, this court should affirm the JCC's decision, giving it the deference it's due. In essence, this court should fulfill Florida's policy aspirations. Thank you.
And thank you, counsel. You may approach, counsel.
Good afternoon, Your Honors, and may it please the court. My name is Jake Pudula, and I too represent claimant Franz Gruber in this appeal. This afternoon, I'll be explaining why the JCC correctly included Mr. Gruber's commission in his average weekly wage calculation. The policy behind Florida's workers' compensation law is to arrive at a quick, fair, and efficient delivery of benefits to an injured worker. The JCC fulfilled this purpose here and should therefore be affirmed for 2 key reasons. First, the JCC relied on the most competent evidence adduced below, Gruber's contemporaneous payroll records. And second, both Florida law and industry standards further support inclusion of Mr. Gruber's commission. Turning to my first point, in an average weekly wage calculation, the claimant bears the initial burden of proving average weekly wage by substantial and competent evidence. This is a relatively low bar that can be satisfied by unrefuted testimony or documentary evidence. And once the claimant satisfies this burden, the burden shifts to the employer carrier to rebut it or to reduce the claimant's average weekly wage. Here, Mr. Gruber satisfied his burden by relying on the most competent evidence adduced below, his contemporaneous employer-generated payroll records. These payroll records show that he was paid bi-weekly and that he earned his $2,600 commission in the 13 weeks preceding his accident.
What about the remedy? You heard me ask during the initial argument. What's your secondary response, assuming maybe we think that you're wrong on the calculation, but what would we do in response to that? Is it just vacate? Should we give instructions if we vacate alone? Does it go back to JCC, and is the JCC free to consider any argument, including ones that weren't made initially?
Your Honor, if you choose to remand this case back to the JCC, we would request broad instructions in line with the question on appeal today, which is whether the average weekly wage was properly calculated. So if you were to remand the case back to the JCC, the JCC should be able to take evidence to set claimant's average weekly wage in a fair and competent manner, as the question on appeal indicates here.
Well, I mean, but we vacate the order. I mean, the order no longer exists, and it would automatically go back to the JCC, and there would be no order, so there's going to have to be some resolution. I don't understand the argument from the appellant as to how any arguments would be waived at that point, because doesn't get restored to the status it was before the final order was entered.
Yes, Your Honor, I would agree with you that there wouldn't be any waived arguments if it is sent back to the JCC. And the JCC should be able to take evidence to arrive at a fair and reasonable average weekly wage calculation. And reliance on payroll records, as Mr. Gruber did here, furthers the policy behind Florida's workers' compensation law as codified in Chapter 440, subsection 015, which is to assure a quick, fair, and efficient delivery and a self-executing workers' compensation system for injured workers here in the state.
Counsel, who remand for an evidentiary hearing for Mr. Gruber to submit additional evidence, wouldn't he be getting a second bite at the proverbial apple?
It depends on what the instructions are, Your Honor. The employer carrier could also get a second bite at the apple depending on those instructions, because it is the employer carrier's burden to refute the claimant's average weekly wage calculation, and it's the employer carrier's burden to introduce evidence in the first place if it's more in their control. That was this court's decision in City of Miami versus Rentonen. So it really depends on the instructions on remand who gets the first or second bite at the apple. Turning to my second point, Florida case law and industry standards further support inclusion of Gruber's commission. Now, appellant relies heavily on Witzke versus West Coast duplicators in arguing that the commission should be excluded. But Witzke is distinguishable here for several reasons. First, as a factual matter, the claimant in Witzke was seeking an average weekly wage that went beyond his payroll records. Here, Gruber simply asks for an average weekly wage that satisfies his payroll records as provided by his employer. In addition, the language in Witzke on this topic was very narrow. It says wages are not necessarily limited to the amount paid. So if anything, the Witzke court carved an exception to the general presumption that payroll records should govern in line with the purpose behind Florida's workers' compensation law.
Counsel, you argue that including the commission in the average weekly wage would be fair and reasonable. How is that the case, though, if the sale which earned Mr. Gruber the commission occurred outside of the statutory average weekly wage period?
Judge Lewis, I would disagree that the sale occurred outside of the 13-week period. The modifications were not paid for, and the vehicle was not delivered until after the modifications were made. And
instead of the sale, of course, the commission occurred outside of the statutory average weekly wage period.
Your Honor, the commission was paid within the 13-week period, but the work was done outside of the 13-week period. That is true. It was done on February 14th and February 15th. But Mr. Gruber's contract provides that it is earned upon sale of the modifications, not necessarily when he does the modifications. And here, on page 3 of the record, it shows that the modifications were yet to be paid for when he made the modifications, and then the vehicle was delivered after he made the modifications. And as this court held in Bonagir versus Home Depot, if any view of the evidence and its permissible inferences support the JCC's determination that the true earn date was within that 13-week period, this court should affirm that JCC's order and the JCC's determination. Judge Lewis, you also mentioned National Distillers versus Guthrie in the prior argument. That is the case that governs here. First, in Witzke, in footnotes 2 and 3 of that case, this court noted a very similar factual scenario as we have here, and it cited to National Distillers versus Guthrie with approval. The facts of that case are very comparable to the facts here. There, the salesman was seeking inclusion of a commission that was paid within the relevant statutory time period, even though he did much of the work entitling him to that commission outside of the relevant statutory period. The court still included that commission, reasoning that it furthers the purpose that I've been talking about as codified in Chapter 440, which is to arrive at a fair and reasonable estimate of a claimant's lost wage earning capacity.
Is that really the proper way to interpret a statute, though, based on policy considerations, or even as to what the facts are, the similarity of facts between two cases, as opposed to just looking at the text of the statute and determining what that term meant at the time it was added?
I see that I'm out of time. May I briefly conclude?
Yes, you may, counsel.
Your Honor, generally, purpose is not permissible to look to over the plain meaning of a statutory enactment, but here the legislature has codified the purpose of Florida's workers' compensation law. So because of that codification, the legislature can turn to that provision in interpreting other statutory provisions. It has the stamp of approval of the legislature, therefore those same separation of power concerns are not present. Now, for these reasons, we ask this court to affirm and include Mr. Gruber's commission in his average weekly wage. Thank you.
You may proceed, counsel.
May it please the court, a few brief points on rebuttal. First, regarding the first issue, the appellee asked this court to consider the word "at the dealership" and that he became well settled in his routine to indicate that he was in the state of Florida during that time. That's an inference that's drawn from this record, which is extremely concerning given the fact that the claimant in this case has the burden to make sure that the facts in which they're going to rely upon are in the record.
Aren't inferences evidence as well?
Inferences can be evidence as well, Your Honor. However, the problem with this inference is that the way that the claimant has the burden to make sure that those facts are in the record. And if the claimant's going to rely on the fact on time distribution to establish compensability, then the claimant should make sure that there's evidence to indicate that he was in Florida and that Mr. Gruber was not working on the 50-50 routine that we're given in the employment contract. Now, turning to the second issue, this court, every time they've considered an average weekly wage calculation, has held that earned means when the work is done. The work in this case was done on the 14th and 15th. That is outside of the 13-week period preceding the accident. In Comerford versus Sunshine Network, this court applies that general rule and ultimately reasons through the meaning of the word earned, meaning work is done. And based on consistency and this court's application of that in the past, we ask that this court also apply that general rule, finding that this commission was not earned during the 13-week period preceding the accident. And it is for the foregoing reasons that we respectfully request that this court reverse. Thank you.
You may be seated. We're going to thank you for your respectful oral arguments. We're going to take about a 5-minute recess. We ask counsel to remain at the table, counsel's table, and we should return in 5 minutes after conferencing the case.
While the court is deliberating, I did want to make some announcements of awards that were received by the teams that competed in the preliminary, quarterfinal, and semifinal rounds. Again, we had teams that were here from multiple states, as I indicated before, but I also wanted to draw your attention to the different schools that have been participating throughout the competition. They're listed in your program, but I just wanted to recognize them. We had teams in the competition this year from Baylor University School of Law, Duncan School of Law, Lincoln Memorial University in Tennessee, from Florida A&M University Law School, from Florida International University College of Law, from Florida State University College of Law, the Frederick G. Levin College of Law at the University of Florida, Jacksonville University College of Law, Michigan State University College of Law, Mississippi College School of Law, Roger Williams University School of Law in Rhode Island, Salmon P. Chase College of Law at Northern Kentucky University, the Sandra Day O'Connor College of Law at Arizona State University, the Shepherd Broad College of Law at Nova Southeastern University, Southern University Law Center at Southern University and A&M College in Louisiana, St. Mary's University School of Law in Texas, University of Miami School of Law, William and Mary Law School, College of William and Mary in Virginia. And with regard to awards, the students have to write a brief that they submit in advance of the oral arguments. They then participate in 2 preliminary rounds, and a third of their score from the brief and each of the 2 preliminary rounds determines what 16 teams advance from that original 26 teams. And then they proceed with multiple rounds of oral argument to get to this stage of the competition. And so our first place brief went to 2 different schools. We had a tie, and this comes down to tenths of a point that tied with regard to the brief. Duncan School of Law, Lincoln Memorial University in Tennessee, and Baylor University School of Law from Texas. They tied for first place in our brief competition. Second place, and on behalf of this school, their coach will come up to accept the award, goes to Florida State University. And the Best Individual Oral Advocate Award, which is the single best student oral advocate out of the 52 students that argued during the preliminary rounds, that award goes to Macy Mitchell with Mississippi College School of Law. So I just wanted to let you all know about the schools participating and the awards. And once the DCA is done with their deliberations, they will come back in and announce the winner of today's final round and give some critique information to the students on their arguments. And again, thank you for attending.
Please be seated. Having judged these competitions a number of times over the years, I thought this was one of the most competitive ones we've had to judge. Both sides did an excellent job. It reflected in our conference following the oral argument. Based on our conference, we have a split decision. It reflects the excellent job both sides did in this case. It was close, but we thought Emily and Nadine did just a tad better in terms of the split decision. So Emily and Nadine prevailed. With that said, now feedback from the judges. I defer to Judge Tannenbaum first to give feedback.
Sure. And I'm not going to give, because I think time is short, I'm not going to give like individual feedback. I will just say overall, I know I was probably the one that asked the left field question to both of you or to both sides, and I want to compliment you on handling that well. And I think that provides a broader lesson when you do advocacy. You probably did not know a ton about work comp before you got in this competition, or maybe knew a little. And I'm sure I did not know more than you when I took this job. And you have to learn it, and like with any subject area. So as an advocate, you always have to, even if you don't know the subject area, you can't rely on the superficial. You have to swim in it. You have to live in it. You have to make it your own, so that when you get up and you argue in court, if someone like me ends up asking you a procedural question or something that you weren't expecting, that's not right in the path, that you're prepared to answer it. You can go off your script or the things that you were thinking about doing and hear what the judge is asking, and it may be a critical point that you didn't necessarily anticipate, but it's obviously going to matter for your case. So kudos to both sides for handling that, and take that with you as you grow it in your advocacy in other subject matter or other areas as well. That just swim in the subject matter, read the statute, and that's another point that I want to make is read the statute, read it again, know it, because that's where we reside. That's what we deal with primarily is the text of the statute. You probably sense that. So kudos to both sides again. I thought you all did an excellent job. Your everyone's eye contact, your rapport with the bench, with the panel was fantastic, all of you. So keep doing what you're doing. Come back, and I hope you pursue this outside of law school as well.
Judge Roberts.
Okay, thank you. Certainly, y'all both did great. Everybody had good eye contact. Everybody had really good poise. There were a couple of out of left field questions that I'm sure that you did not anticipate that you handled really well. Nadine, you got a left field question about what on remand, and you did a real good job with that. Sean, you started out saying and said something about policy, and that got the court's attention because we're a court that typically is very adherent to statutes. And workers' comp is weird too because workers' comp is entirely statutory. I mean, it's a creation of the legislature. It's not, we have cases and stuff, but it's not really a common law body of law. So you have to argue it differently. I thought, Jake, you did a real good job at the end bringing it back and saying the reason we can talk about the policy of workers' comp is because the policy was expressed by the legislature of the statute, and that was a good thing. Everybody had good cases. They remembered their cases. I never saw anybody look at a note. Yep, y'all were citing cases and doing a good job at that. And let it be said that I wish all of our lawyers were as good as you are at oral argument.
My colleagues have said, I don't have much to add to what they've already said because they're very thorough. I thought both sides did an excellent job. What I was very impressed with is how well prepared both sides were for the oral argument and how you answered the questions. You answered each question that was asked of you, and you had what I would consider a hot panel. I mean, we had a number of questions for you. Some, as Judge Roberts said, may have been out left field, but you really answered the question and stay on task. Sometimes you get thrown off base with a question and lose contact where you are, but both sides did an excellent job of answering the question and staying on task. You're both impressive with your oral arguments, and good luck to you in the future. We will remain on the bench for a photo session with you as well.
So are we doing pictures? Or
Pictures
what? Pictures.
with,
Okay.
with,
Yep.
with,
All right.
with the team members.
Where do you want us, Tracy? Okay.
Yeah.
Just to let the audience know, the prevailing team, St. Mary's University in Texas, and the runners-up were from Michigan State University.